There is no doubt the arguments you laid out are arguments that we can expect litigants to bring, partisan litigants who disagree with the policy decision of the President. I would note on January 27, 2017, the Department of Justice issued an official legal decision, a determination by the Office of Legal Counsel, that the executive order, and I'll quote from the opinion, "The proposed order is approved with respect to form and legality." That's a determination from OLC on January 27th that it was legal. 3 days later, you determined, using your own words, that although OLC had opined on legality, it had not addressed whether it was, quote, wise or just.
And I also, in that same directive, Senator, said that I was not convinced it was lawful. I also made the point that the Office of OLC looks purely at the face of the document and, again, makes a determination as to whether there is some set of circumstances under which some portion of that EO would be enforceable, would be lawful. They importantly do not look outside the face of the document. And in this particular instance, particularly where we were talking about a fundamental issue of religious freedom, not the interpretation of some arcane statute, but religious freedom, it was appropriate for us to look at the intent behind the President's actions, and the intent is laid out in his statements.
Final, very brief question. In the over 200 years of the Department of Justice history, are you aware of any instance in which the Department of Justice has formally approved the legality of a policy and 3 days later the Attorney General has directed the Department not to follow that policy and to defy that policy?
I'm not, but I'm also not aware of a situation where the Office of Legal Counsel was advised not to tell the Attorney General about it until after it was over.
Thank you, Ms. Yates. I would note that might be the case if there's reason to suspect partisanship.